All right, good afternoon, everyone. My name is Dr. Angela van der Berg, and as you know by now, I am the director at the Global Environmental Law Center. And the center is really excited to kickstart 2023 with our first webinar for the year. Today, we are speaking to Dr. Melanie Murcott, who is doing really interesting research on transformative environmental constitutionalism and environmental justice, but then also in the areas of climate change and animal law. So we're very excited to host her today. Dr. Melanie is an associate professor. She's based at the University of Pretoria, and she teaches and engages on research on environmental law and administrative law. She is the author of a recently published book. The book's name is Transformative Environmental Constitutionalism. It's published with Brill. If I'm not mistaken, it's based on Melanie's PhD research, which is really exciting. And the book explains the intersections of environmental and climate injustice in a time of planetary emergency, and how the courts in South Africa and beyond can contribute to developing law that is more suited to responding to injustices in this context. As I said, she also focuses on climate law, and she's involved in several projects, one being climate litigation in the global south. And then also she wears an animal law hat, so she's busy developing that field with Amy Wilson from Animal Law Reform in South Africa, and they have a few publications in the works on that as well. But Melanie's author bio has been distributed to everyone who registered, so I think that we're all sufficiently introduced. And Melanie, I just want to say welcome. Thank you for joining us today. And we really are excited to hear about this important work that you're doing. I'm going to give over to you. I'm going to request that if there are any questions, please do keep them until the end. You're also welcome to put them in the chat box. And as soon as Melanie is finished with her presentation, we will open up the floor for questions. Thank you very much.
Thank you, Angela. It's wonderful to be here, and thank you to everyone who came to listen. Today's talk is quite focused on specifically what the Constitutional Court of South Africa is doing around environmental rights protection. And so I've identified a gap that I wanted to share with you all, and propose some ways for the court to start filling that gap when the right cases come before it. I'm going to share my screen, and hopefully, sorry. There we go. All right, so hopefully you can see my screen. And I've started there with a visual representation of which summarizes my presentation. So what I'll be speaking about is the fact that I believe, or have identified, a gap in relation to the enforcement of the environmental right protected in our Constitution at the level of the Constitutional Court. And of course, there have been some developments. It's not all a grim picture, but my position is that there aren't enough developments at the level of our highest court. And so I want us to think about the court a little bit as this snail slowly going over this gap. And what I'd like is for this snail to get onto the other side and start moving faster. And why is that? Well, to contextualize, we're in a time of planetary crisis, and I'm not being dramatic when I say that. I'm not being some kind of tree hugger, not that caring for trees is a bad thing. It's a very good thing, because it's, of course, where we get our oxygen from, and how carbon emissions are absorbed from the atmosphere. But I'm coming at this from a scientific perspective, that we are in a planetary crisis. The latest reports of the Intergovernmental Panel on Climate Change report that the scientific evidence is unequivocal. Climate change is a threat to human well-being and the health of the planet. and a delay in responding will miss the brief. And so if you start to read these intergovernmental panel on climate change reports, which those of us in this area are doing as part of our interdisciplinary work around environmental law, the picture is alarming. And what is particularly alarming is that as much as all of us are affected by climate change, those who are living in conditions of poverty and people who are Black and brown are most affected and most immediately affected. And so there is a social justice implication for not responding. And those who can afford to respond and adapt, those with adaptive capacity, are of course able to address the problem differently. And as much as scientific reports like the IPCC report hope to offer solutions, we need action at every level. So we need systemic action. And part of the challenge with climate change is that humans have been recognized as a geological force. So humans are creating the problem, but of course that means that humans can contribute to responding to the problem. Another important caveat I want to make up front is that as much as humans are a huge part of the crisis, it's not all humans who are contributing equally, and not all humans who are impacted equally. So the crisis that the planet faces is caused primarily by industrialization and domination and colonization of the globe by the global north that affects the global south most acutely, despite the global south being least responsible for the problem. And so emissions, for example, in most countries in Africa are significantly lower and have been historically in comparison with emissions in, for example, the US and many places in Europe. And so this historical contribution for climate change is a significant justice issue, but it's also one that's not only global, it has local implications for people who are experiencing suffering right now at this minute. Even the recent disaster in Turkey, there is evidence around Black and brown people suffering most acutely because, for example, their houses are weren't sufficiently strong to protect them from that disaster. And so we see patterns of disadvantage linked to these global problems. And part of the challenge is for us to see the connections, to diagnose the problem so that we can become constant firefighters. So I'm not alone in making this argument that there is a connection between social justice and a proper functioning socio-ecological system. There are many others around who are making these arguments. And so we see, for example, in 2019, the UN Special Rapporteur on Extreme Poverty and Human Rights, Philip Alston, warning of a climate apartheid as climate change would deepen injustice and inhibit the fulfillment of human rights. More recently, last year, we heard the UN Secretary General, Antonio Guterres, speak about how our climate change reporting at a global level reveals an atlas of human suffering, that delay in responding means death, which we are seeing all the time. And so we need radical responses. In reaction to this, there has been some global action. That's the good news. And we need to think about how we can implement it and make it real. So one example of global action is the UN General Assembly resolution passed last year, which introduced an environmental right in the global stage. And that resolution was passed recognizing that further environmental degradation, climate change, biodiversity loss, and other harms constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy human rights. So I'm putting it to you, it's a simple proposition that human rights are affected negatively, and our ability to enjoy human rights is affected negatively by environmental harm. And I don't think that there can be much dispute about that. Of course, if we don't have a proper functioning environment, we cannot have access to water. If we don't have a proper functioning environment, our access to food is threatened. And of course, a range of other human rights are threatened. The ability to live is threatened. So the right to life, one of the most fundamental. The ability to live in dignity is threatened. So all of these intersections mean that we need to take our environmental protection tools in the law seriously and make sure that they are implemented properly. So the UN again affirmed the importance of a clean, healthy, and sustainable environment for the enjoyment of all human rights of all people, recognizing that all people have equal moral worth. So we shouldn't have a situation of some people enjoying a clean and healthy environment and the majority of the population of the world being confined to human suffering because other people are enjoying their human rights. We should have a situation where all people are able to enjoy human rights. And in addition to these global instruments, there's a lot of philosophical justification around what I'm saying, and philosophers who have connected the links between social, environmental, and climate justice. So the idea that goods and bads shouldn't be unfairly distributed in our society. There should be an even or an equitable distribution of the good things in the world, and there should be an equitable distribution of the bad things in the world. And that way we can all hold each other accountable. It shouldn't be the case, as it is, that purely by virtue of being poor, people experience more of the bad things in society, like pollution, and purely by being rich, people get to be protected from the bad things in society. And so if we look at what these connections mean in philosophical terms, we see that Sen has spoken about how social justice is about preventing manifest injustice in society, making sure that there's an even share of goods and bads, and that you don't, purely by virtue of being poor, suffer more than other people who have more resources available. Schlossberg highlights the crucial point that the environment is what creates the conditions for people to experience social justice. So we can't have social justice and people living with dignity and equality if we don't have a proper functioning environment. This claim was expressed differently by the late Desmond Tutu, that the concept of Ubuntu doesn't only speak to I am because you are, but also we are because the planet is. So Desmond Tutu expressed this idea that we are in the fullness of being human, not only human because we coexist with other people and respect other people, but also because we as a collective coexist with the planet. And then Carmen Gonzalez reminds us that we need to recognize that there are big systemic and structural issues that implicate how the environment functions and how people function within environments. So she highlights that we need to recognize that colonialism and the commodification of the environment, as well as the creation of a global economy that subordinates people in the global south, are global justice issues. So we think about responding to justice, which is in my view what or rather responding to injustice, which is what the law in my view should do. We have to recognize these different layers and connections and not think in silos. And so what tools do we then have in South Africa to grapple with or respond to these justice issues? Well, there are many, many tools. So among others, we have the environmental right, which is enshrined in our Constitution, a right to an environment not harmful to health or well-being, that it accrues to everyone, and a right to have the environment protected for the benefit of present and future generations, including through measures that prevent pollution and ecological degradation, promote conservation and secure ecologically sustainable development, while promoting justifiable economic and social development. This right operates amidst a basket of other rights in our Constitution that are to be viewed as mutually reinforcing of one another and interrelated. So the environmental right is meant to be viewed as interrelated with the right to life, the right to dignity, the right to equality, children's rights, the right to food, the right to water, and of course, many other rights that are interrelated with a proper functioning environment and cannot be fulfilled without a proper functioning environment. In addition, there are procedural rights that promote participation about decisions that affect the environment and affect people. There are rights to access to information that enable transparency about decisions that affect the environment and affect people. There are rights to access to justice that allow people to go to court to enforce their rights. These rights apply both vertically, so we can enforce them against the state, and in some respects, horizontally, so we can enforce them against each other. And the environmental right is one such right. So, and it's important that this right advances what we call, as legal scholars, we call environmental constitutionalism. This right, alongside the other rights that I mentioned in the Constitution, are aimed at environmental protection. And so when they are enforced by courts, we see the implementation of environmental constitutionalism. South Africa isn't alone in protecting the environment in its constitution. Around 170 national constitutions address the environment, and around 85 expressly provide for a right to a healthy environment. And the idea is that by constitutionally protecting the environment, we can elevate the protection of the environment as a concern of the law and help to promote the health of the environment and social justice for the people who live in those environments. And so there are many advantages to environmental protection, among them the idea that when you protect something in your constitution, you can create a shift in society about the way that thing is viewed. So here we're saying we protect the environment, so this is a thing that's worthy of concern as a matter of law. And various features of environmental constitutionalism and benefits of environmental constitutionalism have been recognized in our courts. For example, it's been held that by virtue of this environmental right, environmental considerations which were often ignored in the past to the detriment of people and the environment have now been given prominence in the Constitution. But of course, there are many criticisms of environmental constitutionalism too. I don't want to be coming across as not nuanced and not aware of these criticisms. I'm not going to go into those for present purposes, but when I publish on this, those will come through. One of the things that's of course crucial is that you can't just have law on paper. You have to have law in action. And of course, there are many ways in which law is put into action, but one of them is when courts interpret and enforce rights. And so that's really getting to the nub of my presentation, is what is happening with the interpretation and enforcement of this very important right that advances environmental protection. So we're moving on to that now. So I've done a little snapshot for you. This snapshot, this little timetable of environmental cases that have come before the Constitutional Court reveals several opportunities, some of them missed opportunities, to develop the content of our environmental rights. So for courts to put into action our environmental rights, tell us what it means and enforce it to help protect the environment. And for our highest court, the Constitutional Court, to then make sure that other courts understand what the environmental right means and how they can use it. So we start all the way back in 2005, so almost 20 years ago, frighteningly. We had our very first case where a private person came to the Constitutional Court directly to enforce the environmental rights. And unfortunately, the court kind of just, it had to, and I don't take issue with this, the court for procedural reasons had to say, you, Mr. de Kock, should have gone through the proper legal process before coming to us to protect the environmental right. And we can't hear you, the Constitutional Court said, as a court of first and last instance. So that was a bit of a disappointment for Mr. de Kock and for the interpretation of the environmental right, but it just wasn't the right moment. So a missed opportunity to interpret the right. Then we had a huge constitutional moment relating to the interpretation of the environmental right in 2007, when we had a group of fuel retailers challenge the approval of a new petrol station. And the facts aren't particularly important. I won't go into them. This judgment has been both praised and criticized, and I won't go into all the criticism. But what was useful about this judgment, from my point of view, is that the court, the Constitutional Court, so our highest court, emphasized the crucial role that courts must play in protecting the environment, adopted an intersectional approach by recognizing that the protection of the environment is vital to the enjoyment of other rights, including the right to life, advanced the notions of intra and intergenerational equity, so equity in relation to the protection of the environment for present and future generations, and then also recognize that the present generation holds the earth in trust for the next generation, so advancing a trusteeship role of humanity over the environment. In addition, this judgment, Fuel Retailers, is known for its interpretation of the concept of sustainable development as an aspect of the environmental right. So the court set aside a decision to approve a new petrol station, and doing so told us a little bit about this, what this environmental right means. It told us, among other things, that development cannot subsist upon a deteriorating environmental base. Those of you familiar with environmental law will have read that quote many, many times. The court said, unlimited development is detrimental to the environment, and the destruction of the environment is, of course, detrimental to development. So the promotion of development requires the protection of the environment. In some ways, what the court is saying is that we can't just have any which development we want. We have to think carefully about these intertwined issues of environmental protection and human development. And so the court mentioned that there must be a balancing of socioeconomic issues in development decisions with environmental issues. And as significant as these pronouncements were at the time, they're now a little bit dated. At the time, as much as the climate crisis had already well begun and was well known, as much as 15 years earlier, there was a lot of knowledge about it. courts weren't grappling with the climate crisis, and they weren't thinking about its holistic impacts and the need to respond holistically. And so this rather now simplistic statement needs to be built on. And so we need new constitutional moments. But what have we had? Well, instead of big constitutional moments, in general, we've had the court just reiterating, for example, here in HTF developers, what it has previously said in fuel retailers. We've had decisions that related to environmental issues such as BioWatch, where the court didn't speak about the environmental right in a meaningful way, but focused on the issue of a cost order. Then we've had gaps, so long time periods when basically nothing has happened. And then, and in these times, just by the by, we've had cases that have come on appeal from the Supreme Court of Appeal, where the courts have, where the Supreme Court of Appeal gave a favorable judgment to protect the environment and did say something about the environmental right, but the court decided not to add. So the court just dismissed those appeals, so upheld the environmental outcomes from the lower court, but didn't add to them. So it didn't give us some content around what the environmental right means. And so then we had another big constitutional moment in terms of the court telling us a little bit about the environmental right and what it means in 2016, when the NSPCA was trying to assert its right to privately prosecute an offense relating to animal welfare. And there the court upheld the NSPCA's claim, and in doing so, told us a little bit more about what the environmental right means. So the court told us that animal welfare is connected with the constitutional right to have the environment protected. So for the first time, we see that this environmental right includes protection of animal interests. The court said that animal welfare and the protection of the environment are intertwined values, and also recognize that animal welfare and animal conservation are related to one another. And so we see that this obiter remark has helped take our jurisprudence a little bit further, but not a whole lot further. And since then, since 2016, we've had a few cases where, as I mentioned, the courts have dismissed appeals, so upheld good environmental outcomes from the Supreme Court of Appeal simply by dismissing an appeal against the Supreme Court of Appeal's judgment without a hearing. And we've had a really interesting case about land and evictions of Indigenous people from land, and those people were trying to protect the environment, again, without the court speaking to the environmental right. Now, some of you might be listening saying, well, maybe the environmental right just wasn't argued, and that may, I know for a fact that that's not the case in all of these, but to the extent that, for example, in Maledu, it wasn't raised as a prominent issue, the courts have in the past, in relation to other rights, spoken about environmental rights, or at least about other rights of their own accord, so meremotu, and they are empowered to do that in cases like Maledu, where the environmental right is so prominently before them or at issue, even if not explicitly argued. Again, I hear the criticism that I may be asking the court too much of the court or expecting too much of the court. But then I take you back to the previous slide about the need for us to put environmental rights into action to respond to a planetary crisis with grave social justice implications, and say that actually we need to ask a lot of the courts and we need them to be thinking about these issues, but we need lawyers to be bringing the issues to and the arguments to. So we need to do this together. There's a couple of other cases that could be mentioned that I won't go into for time. The most recent case was last year's case about a strategic litigation against public participation defense, where a corporation tried to stop environmental activism from taking place and environmental litigation from taking place, and the court upheld a defense against corporations trying to prevent environmental activism. That case, again, you can see it is squarely about environmental issues and about people trying to protect the environment, so uphold the environmental rights, but we don't really see any meaningful engagement, once again, with this right. So the focus is on abuse of process by a corporation rather than on how that can stifle the protection of the environment and the fulfillment of the environmental right. So we clearly need some jurisprudence, again, updating fuel retailers and advancing the protection of the environment. But the picture's not all bleak. So there have been some really promising developments, in my view, in the courts, high courts and Supreme Courts of Appeal, that have made some brilliant pronouncements on the environmental right. So we see many administrative law reviews that are imbued with rights-based approaches that are seeking to protect the environment in pursuit of social justice. And so these cases mainly relate to challenges of the lawfulness of environmental decision-making by government and seeking to set those unlawful decisions aside. And the good news is, for those of us who are concerned with environmental protection, that these cases were successful and that there was some engagement with the environmental right. And most notably, we see engagement with the environmental right in the recent case last year, Groundwork Trust. Now, Groundwork Trust was seeking to prevent, or at least to compel the government to take measures to clean up deadly, literally deadly air that is killing thousands of people every year in the Highveld as a result of, among others, Eskom's coal-fired power stations. And women and children, the evidence before the court showed, are suffering the most from this pollution of the air. And the government, contrary to its obligations under the Constitution, resisted the idea that it was required to put in place a plan to clean up the air. And so challenging that resistance, the deadly air case was able to result in an order compelling the government to put in place a plan to clean up the air and improve the air quality for the people living there. The court, in doing so, said a lot of very interesting things about the environment. So first of all, or at least the environmental rights. First of all, the court spoke about how poor air quality falls disproportionately on the shoulders of marginalized and vulnerable people who bear the burden of disease caused by air pollution. So the court acknowledged that air pollution is a social justice issue. So the court there connected social, environmental, and to some extent climate justice, given that the air pollution is causing emissions that exacerbate the climate crisis. So importantly, the court recognized these justice implications of poor air quality, sort of reinforcing Schlossberg's point that it's the environment that creates the conditions in which social justice can occur. Then the court spoke a little bit about what the environmental right is supposed to do in response to these kind of conditions and why it is the government should be compelled to take action to uphold the environmental right. So the court said that the environmental right creates a meaningful nexus between the environment, human health, and well-being. And so the right recognizes that there's a relationship between one's health and the environment in which one lives. Now, this shouldn't be radical. Any of us who've been in a bad environment know that it can affect our health and it can affect our well-being. But the court saying it is important because it tells other courts how they can enforce this right too. And then the court said a particular environment may be damaging to a person's health, yet avoid falling foul of the right to access to healthcare protected elsewhere in the Constitution. So the court said health is unarguably a component of environmental concern that falls within Section 24 of the Constitution. In addition, drawing on Anel du Plessis' work, the court said that the environmental right isn't only concerned with good health outcomes, so preventing disease outcomes, but also is concerned with protecting well-being, which is something more than just health. And so the court referenced Anel du Plessis' comment that well-being relates to instances where environmental interests which do not necessarily have evident health implications are affected, so something more than health. And the court also highlighted that the right can be invoked purely for the benefit of future generations, so people who are not yet born or the very, very young, potentially. And lastly, the court, well, there's a lot more I could say, but for time purposes, I'll keep it to lastly. The court said that this right is immediately realizable. Now, there are some criticisms of this finding, and of course, there's an ongoing appeal, but I think it's an important statement that it'll be interesting to see how it plays out moving forward, that this right is not realizable in the future, but also now. And so in finding that this right is immediately realizable, the court said that the people who are literally dying, thousands of people every day, and who are suffering from ill health effects, have the right to live in conditions in which their health and well-being is not harmed by dangerous levels of air pollution. And so the court said that the state should not cause this problem. It should prevent this problem rather than causing this problem. And that there was an admission on the part of the state to do something, to take its reasonable measures. And so the court advanced the idea that the right can be fulfilled in an immediate way in this judgment. Of course, there's a lot of nuance that I'm skipping over, but I think it's worth noting that this is a really important judgment telling us some things about the right that we haven't seen before coming from the court. And hopefully, if this case reaches the Constitutional Court, the court at that point will reinforce these ideas of social justice, recognizing that our Constitution and the court's role in upholding it is ultimately to be informed by a social justice imperative, and in turn, that social justice imperative cannot be fulfilled without a well-functioning environment. So what do I say the court should do in responding? So the Constitutional Court in trying to fill this gap when the right case comes before it. Well, first of all, I think the court should embrace the next opportunity. There are important reasons for this, and hopefully will do so with reference to what the exciting developments happening in the Supreme Court of Appeal and the High Courts. I didn't touch on all of them, but there are lots. And so obviously my hope, and this isn't purely self-promoting, this work is done precisely to encourage good environmental outcomes that promote social justice. My hope is that the courts will advance transformative environmental constitutionalism, that I speak about it in the book that came out last year. So what does that mean? Well, like the court did in the deadly air case, the High Court did, it's important that the litigation concerning the environment is framed in a justice-oriented manner, that those most vulnerable and most impacted are recognized and identified. So there's a human face on the impacts of the harm to the environment, and that the need to address the social injustice that they are experiencing through environmental and climate protection is advanced. So recognizing that different forms of injustice intersect and our legal responses must equally adopt an intersectional approach. Second of all, I say that the courts should adopt what's referred to by many authors as substantive adjudication or transformative adjudication towards the environmental right, including through meaningfully interpreting and applying key justice principles, and including through telling us more about what key terms in our environmental right mean, like ecologically sustainable development and intergenerational justice and how we fulfill those. So I say that when the court is confronted with its next opportunity to interpret this right, they must first engage substantively, so look at the context, the history, the climate crisis that we're in. They must engage meaningfully with our environmental rights, and they must draw on justice-oriented principles in our environmental law. And then lastly, the court must hopefully, so this is my plea to the court, of course it can do whatever it wants, the court should engage with the environmental rights in conjunction with relevant mutually reinforcing and interrelated substantive rights. And one brilliant example of this is how the court in the High Court in the Sustaining the Wild Coast litigation viewed the right to culture as connected to the environmental right and recognized the community who was resisting a new fossil fuel development off the Wild Coast, recognized their role as custodians of the climate system and recognized how the right for them to protect their, or at least their cultural rights and their desire to protect the cultural right and the desire to protect the environment were intertwined and mutually reinforcing of one another. And so there are a range of other ways in which similar arguments can be advanced. So my conclusion is, if we go back to the snail, that the court needs to stop being a snail and needs to join the fight, because climate issues are life issues and we all have to keep fighting. This isn't a fight that's ever going to end, by the way, not in our lifetime or I think any foreseeable lifetime. It's a fight we have to all continuously take forward, as Vanessa Nakate reminds us. Well, thank you very much.
Thank you so much, Melanie, for that engaging and really thought-provoking presentation. I already have questions, but I don't want to hijack. I'm going to open up the floor. I see we did have a question in the chat just about where the cases can be obtained, but I answered that. Does anyone have any questions for Melanie regarding the substance of her presentation today? You are welcome to put your questions in the chat or just to raise your hand and we'll facilitate a discussion from there.
So sorry, Angela. I do apologize. I cannot raise my hand. I don't know if it's a fault on my end. You're speaking to Nonhlanhla.
Oh, all right. Hi, Nonhlanhla. Welcome. Thank you. Do you have a question for Melanie?
I actually have what could perhaps be a point that she could maybe perhaps entertain me on. It's especially regarding the last case that she discussed, which is the deadly air case. So if you are willing to entertain me, Prof, please. Thank you. So with the last case that you just spoke of, which is the deadly air case, that research judgment for me, I was just reading it this weekend, and I sort of found that perhaps one of the problems that we might just face in the near future is how we are just according so much responsibility on local government. And I'll say why I say this. I find that with that case, the judge really does state how national government or the minister has failed to come up with a plan that must be able to alleviate the air pollution that they have in the Highveld. But then the immediate realization part for me comes in most when it touches on local government. And so my problem then becomes that, as you've been speaking of this systematic reaction that we should be having from all spheres, I fear that we might find ourselves according way too much responsibility perhaps on local government, sort of then letting provincial and national government think, or letting them perhaps think that they've got a lesser responsibility. It's funny for me because even the schedules, much as they speak about the environment being in 4A specifically for national, but jurisprudence and perhaps the courts themselves are just, I feel they're jotting way too much for local government, that it might then say, for the other spheres, then it might be an issue where they think that they have no responsibility or a lesser responsibility. I tend to muddle, but I hope my point came across, Prof. Thank you.
Thanks, Nonhlanhla. Is it fine if I respond, Angela?
Yes, you're welcome to respond or to take another question. What do you prefer?
I think let me respond to that one. It was quite weighty and
Okay.
very interesting, and then we can come to the others. I see there's one in the chat, and Sandy also has a hand raised. So I take your point about the potential of orders and reasoning by the courts imposing too much of an obligation on one sphere of government. And that's certainly not what I'm advocating for. So I think the responsibility must be shared at the appropriate levels. I don't think that the judgment imposes the immediate realization of the right on local government specifically. I think the immediate realization comes to the minister preparing and initiating regulations to implement a plan to address the air quality issue in the Highveld. So it's the obligation is then, the immediate realization part is imposed on national government. And of course, that plan will implicate local government, but I think it's within the three spheres for them to work out how that responsibility is shared. I do recognize that air pollution is a local government competence, but I think that there is scope for them to engage on how they fulfill this particular plan. So I'm not saying that this is a simple thing to do, and I'm not really speaking to the roles, which I realize is a gap in my presentation. It's not the focus of, oh shucks, am I still there? I think so. It's not the focus of my presentation. But certainly there is an important discussion to be had about how responsibility for fulfilling the rights as they are interpreted by the courts is to be done. I don't think the court's been overly prescriptive. The court's given the minister a range of things to take into account in preparing the plan, and the court has told the minister what the environmental right requires of her, but the court hasn't told her precisely how responsibility is to be allocated. And I think that is where you, Nonhlanhla, and others who are experts in local government need to come in and say, what is the proper role of local government? And I see your scholarship is doing that all the time.
Thank you, Melanie. We have a question in the chat just about what the role of international environmental law would be. So the UNFCCC and the Paris Agreement. Maybe you can hold on to that thought, and I can give Professor Liebenberg a chance to ask her question, and then you can answer, and then we'll go to Professor du Plessis and other questions.
Sandy, are you there?
Hi.
There we go.
Hi. Congrats, Melanie, on your book. And yeah, it's a wonderful contribution. And of course, also to your, really great presentation. So it's more some comments and then inviting your reflections. I mean, the sort of some of the lessons that come, perhaps from the socioeconomic rights field, and that, I think with environmental rights, as you say, really needing to gain impetus at this moment of crisis we face, is this whole challenge of how the court sees its role in giving substance to rights. And, you have, for example, statements in Mazibuko that, in the context of the right of access to water, that it's not the court's role to give substance to the rights. They acquire rights through the legislature, giving them content, and then the court only reviews the reasonableness. And then, you have, in my view, a very deferential reasonableness test being applied in that context. So, obviously that's going to be relevant, particularly to Section 24B, the qualified portion of the environmental rights. So I think it's, a broader struggle to get the Constitutional Court to give content to rights. I mean, sort of cutting across socioeconomic rights and environmental rights. And I really welcome that part of your book. And I think, in fact, Fuel Retailers is quite remarkable for the willingness of the court actually to talk about sustainable development and its elements, even though arguably not all of that was relevant to dispose of the narrow issues in the case. And then just my second point, and as you know, I'm sort of heading this project, the drafting committee on the Maastricht guidelines on the human rights of future generations, and whether you think there's potential also for litigants to use the future generations clause in Section 24 to also litigate for future impacts, not just for currently living children, but also generations hence, particularly in the context of fossil fuel projects and climate change. Thanks.
Thanks, Sandy. I really value that insight, and I agree there's a general problem with the courts viewing its role in quite a restrained way around interpreting rights. But what I tried to do in the book is to show some good examples of where the courts have taken steps and how the court can build on those. And of course, how the court can do so drawing on what is already in legislation. So hopefully that creates some basis for the court to give us some content on some of these key concepts. And of course, substantive adjudication isn't only about giving content to rights, it's also about looking at purpose and context. And I think what the environmental rights is what's useful about it is that we are in this moment of crisis. It's not a moment, it's a period. And so my hope is that drawing on that scientific reality and its implications for human rights could create a bit more impetus for courts to engage meaningfully. But of course, I'm not naive about this. It will take some very creative and creative lawyering. And I think part of the role of those of us in academia is to inspire those in practice to think about the tools that are available and how to optimize those tools in the cases that come forward in the future. And then I think that Deadly Air has created a space for future generations to enforce these rights. It's really a very short remark about that possibility. So we could do with some scholarship on it for those who, and so your project is very timely and very important, I think. And there's a growing body of scholarship around the need to protect future generations around the world. So I think that we certainly have the potential in our constitution, so the textual potential in our constitution for the right to protect future generations, those not yet born. And I think that that's something we should be pushing for, because of course, if we're advancing social justice, it's the future generations that will be most deeply impacted by the legacy that is left behind. And then very briefly, before we go to Anil, on the role that international environmental law can play, there is a huge role that international environmental law can play in advancing transformative environmental constitutionalism. So the big reason for this is, of course, because our constitution tells the courts that they may consider, or they must rather consider international law, and they may consider foreign law. And what's happening in terms of litigating in response to climate change and in response to environmental destruction isn't unique to South Africa. There is this huge body of case law emerging around the world with really exciting developments, where courts are compelling governments to take more aggressive climate action, to implement their climate laws, to uphold the requirements of the Paris Agreement, to play their fair share in terms of keeping the globe to this 2 degrees Celsius or 1.5 degrees Celsius temperature goal that's in the Paris Agreement. So what our constitution does is it creates an opening for those principles in international law and developments in other courts around the world to be used. And we've seen a bit of a drop-off in terms of reliance by the Constitutional Court and other courts on international law and foreign law. And I think that that's a capacity issue largely. So it's important for us to be really reflecting on the exciting things happening around the world in response to climate change and the human rights implications of environmental destruction, and to draw those lessons, which our constitution explicitly allows our courts to do. And then over to Anil.
Thank you very much, Melanie. Angela, also for having arranged this event, dealing today with a topic that's very close to my heart. And Melanie, I haven't seen you in person yet, but congrats again with the publication of your book and also your promotion to professor. It's fantastic. Some of the issues that I wanted to flag, you already addressed, eloquently so. And I think I would just like to leave you with one comment to which you could possibly respond. I'm just wondering whether we might not end up considering the complexity around the global ecological crisis from a scientific point of view, with a situation where we should be careful what we wish for, considering especially the Concord and the people on the bench not being environmental experts of sorts, and that also goes for the lower courts that you've mentioned. And that brings me to our constitution calling also for the promotion of rights. And I think that I'm wondering whether we are doing enough to promote this lovely section 24 that we have, very broad in its language. And I'm so glad to hear also about Sandy's project, just showing how forward-looking the constitutional drafters have actually been when our section 24 was crafted. And that well-being that you also alluded to having been such a prominent feature in the deadly air case. And perhaps just to latch onto the point I'm trying to make about broader promotion of Section 24, also among legal practitioners and those that are litigating, it might be interesting to know that it's not a matter of my scholarship having been so great and visible and therefore was cited in the deadly air case. the applicants and the lawyers for the applicants had 3 interviews with me, personal interviews in Potchefstroom, leading to that case, where we could sit down and really talk through some of their arguments and some of the existing academic interpretations of Section 24. So I just wanted to make that point here that perhaps we should be looking at using Section 24 in the courts, but also before going to court. I'm looking forward to your response.
Yeah, I completely agree. I think one of the nice things about this digital world we live in is that there's that much more space for science and scholarship and practice interaction. And so personally, I've experienced it too, that I've been able to interact with lawyers in practice, especially in these kinds of cases. And we certainly need to develop incentives for that and encourage the great work that you're doing. I mean, of course, your work is very visible and it is very important and relevant for these kinds of cases. But it's also brilliant that we are, as scholars, are able to interact more, as you say, given the complexity of the issues. The one sort of pushback I would have in response to your comment is that all issues that go before courts are complex. Environmental issues are not the only complex issues, or some are more simple than others. But courts, they are not experts in implementing legislation or in creating legislation, but they are experts in hearing evidence, in distilling that evidence, in working out what is legitimate and what is not legitimate. And so when lawyers who are engaged with scholars, such as yourself, are able to bring that evidence before the courts are very skilled in dissecting and engaging with that evidence, and that is their job. And so where there is, as we've seen, there is unequivocal evidence on certain issues, there I think it's quite proper for the courts to engage with that unequivocal evidence and to make findings, of course, about principles that will guide application and will guide implementation by the government. Of course, not to tell the government what to do. That isn't their role, and that's not what any of us, I think, suggest. But for them to be aware of what their responsibilities are. And in my view, the Deadly Air case was like quite a, I don't know, it's like the evidence was so overwhelming that people are dying. And our jurisprudence tells us that the rights must protect the most vulnerable. The most vulnerable in our society was dying as a result, are dying as a result of government's inaction. And to me, that's an easy case, where if there's a clear connection between government inaction and death of the most vulnerable, those people are not enjoying their right to an environment not harmful to health or well-being. And so I think that in those cases where the court is able to solve the issue without trampling on the separation of powers, the court must welcome the opportunity. And my main argument here is to point out the Constitutional Court hasn't yet done so beyond the 2 examples I gave, and to say that when the next opportunity comes, I hope they'll take it and to offer some ways for how they might do that. I see Jean-Claude has posted a very challenging question about equality and whether rights and rights are more just mere political declarations and rarely achievable. You know, I appreciate the question, because of course rights are not some kind of cure-all, and they're only meaningful when implemented. But in response to that, I can only say, what would we have if we didn't have rights? What would we be able to do? And so the reality is, rights in our constitution are the tool that we have today. And I consider it my role to work out how we can best utilize them, flawed as they are, limited as they are, to advance social, environmental, and climate justice in this time of planetary emergency. So my proposition isn't that they are some kind of brilliant fix-all or immune from criticism, and that they, of course, rights can, if they're not put into practice and not used to best effect, can be reduced to mere political declarations. But in South Africa, we, compared to other jurisdictions around the world, even in Europe, where we're seeing some exciting judgments come out, we have an incredible basket of rights available to us. And we have generous standing provisions that allow public interest litigation. That's quite unique. We are able to hold corporations to account. So as problematic and limited as rights may be, we need to work out how best to use them, because they are the tool we have today. And of course, we don't have an equal world. We live in an unequal world. But I consider it our task as lawyers and academics and those of us who are concerned about the environment to work out and constantly advocate for a more equal world. And so I take the criticism fully on board, but you know, I continue to try and be simultaneously realist and optimistic at this, you know, as much as one can be.
Thank you everyone for the questions so far. Maybe I will take an opportunity to ask a question. I also wanted to ask about your thoughts on Section 24 being, for the most part, classified as a socioeconomic right, which is progressively reliable, and what you think might happen if this case escalates to the Constitutional Court, and how this could potentially be reinterpreted, and what this could potentially mean for other socioeconomic rights linked to Section 24. Although I know we can't predict, so I just wanted to hear your thoughts on that. And then maybe taking the discussion in a slightly different direction, just because I know your research is also linked to this. There are quite a number of scholars doing a lot of forward-thinking work on the notions of justice and environmental justice and climate justice, and looking at transformative justice and what that might mean. And what that might mean also in the context for non-human animals, for nature. We are intertwined, humans and nature. And what your thoughts are on that for the role of the court. I know that we haven't had a case like that in South Africa yet, and maybe this is jumping the gun, considering that we have so many other issues to deal with in terms of socioeconomic rights. But do you think that we might see a case like this in the future, or do you have hope for someone approaching a court and using an environmental justice argument, but for nature, for example, in South Africa?
Yeah, I mean, these are really the big issues, right? They need their own presentation. So both really very interesting questions. I think in relation to the environmental right being a socioeconomic right, so my view is so I don't really subscribe to these classifications of rights and compartmentalization of rights. I think that all of our rights are to be viewed as interrelated and mutually reinforcing. And I think that the environmental right potentially has a special status. It hasn't been interpreted this way yet. But the fact that none of the other rights can be fulfilled if the environmental right isn't protected, something that the court in the Deadly Air case recognized. And I think it would be good if the Constitutional Court was to proceed from that premise, and that might inform these kind of more formalistic issues around progressive, not progressive, Because of course, textually, there's no word progressive in the right. That doesn't mean that certain aspects of any rights can't be progressive or shouldn't be required to be only progressively fulfilled. But to me, sort of mechanical or formalistic arguments that try to hem us into all or nothing positions are unhelpful. And so my hope is that the court will recognize, first of all, the significance of this right, will grapple with what some of the key concepts in it mean, and will not adopt a formalistic interpretation of the text, but will view it purposefully and contextually in the moment we find ourselves, which is a moment of environmental crisis. So I don't want to speculate more about what the courts do, but of course, what the courts do is informed by what we as practitioners and scholars say and what we advocate for. So I suppose that's why I'm here kind of preaching to the choir, as it were. And then around cases about recognition of the rights of nature and the rights of animals. So what the NSPCA case did, as you know, is acknowledge that animals are sentient beings and that they have intrinsic value. So we already have the judicial recognition that animals are sentient, and that must mean something, right? And I think Professor David Bilchitz has written a little bit about how if something is sentient, that's the primary condition for rights attracting to that thing, or that being. And so I think that the opening is there, given that the Constitutional Court has recognized the sentience of animals, for greater protection of animals under our law. And again, given the interesting developments in Ecuador and in other parts of the world where animals' rights are being increasingly recognized, I think, and our ability to look to foreign law, I think that there is some scope for this area to develop. And of course, my work with Amy Wilson on this is part of encouraging that movement. So I think that there's space and an opening for animals. The nature question is more complicated, I think, but where I think the opening lies is in the idea of Ubuntu. So the courts have recognized that Ubuntu flows through our whole constitutional scheme and is a principle on which our constitution is based. And if we look at how Desmond Tutu and many other scholars have understood Ubuntu, there's an element of recognition that we need to coexist with nature and respect nature, and that we are not separate from nature, but that we are part of nature. So if I were to try and develop that area of law, I don't see our environmental right being interpreted as a right of nature. I think we would have to have a wholesale revision of our right, which other constitution, or at least one other constitution in the world has had in Ecuador. But so I don't think a revision of the right is impossible. I don't think we're anywhere near it, but I don't think it's impossible. But what I do think is that we can start to advance interpretations that recognize that we coexist with and are dependent on nature, and that human rights cannot be fulfilled if we don't recognize the significance of nature and our connectedness to nature. So that for me would be the end and the starting point of what I think is a very exciting area of law. Again, there is some brilliant judgments elsewhere in the world that we could draw on and potentially prevail on the Constitutional Court or other courts to recognize nature as you know, at least having some form of interest in our law, if not rights. And for me, you said, you know, maybe it's not the most important thing. We haven't, I think in some ways, the reframing of our relationships with the environment is the most important thing, because that's the foundation, it's the starting point for how we engage with rights in general, and how we understand our law. And also it's an opportunity to emphasize and recognize indigenous knowledge about the relationships between humans and the environment. So I think it is incredibly important, and I encourage everyone to go and reflect on why a river and a tree and all the components of nature shouldn't be afforded the same protection at a fundamental level, obviously not in the detail that we as humans have.
Thank you, Melanie. Now, I completely share your sentiments about Section 24 being reinterpreted and less from, you know, moving away from our very formed, rigid interpretation of the right. And you remind me of interesting work being done on the concept of ecological Ubuntu and what that might mean for environmental rights protections in South Africa, which is something I'm also very interested in and advocating for. We'll have to see how judges, I guess it's about judicial interpretation and what we will draw from other courts around the world. So thank you for that. I'm going to allow for one more question. I see, oh, we do have a question from Mr. Bason Galdenes. Bason?
Yeah, thank you. It's more a comment. I think, Melanie, when you were saying that we should take our law seriously, and I totally agree with you, because there's a few examples that are practical examples of DMR. You have two different decision-making bodies, DFFE, and then you have DMR. And what's happening is, for instance, on discharging permits, who's policing that, you know, and because the authority lies with DFFE, for instance, and even with dumping at sea permits, and that becomes a confusion, you know, and the one hand does not know what the other hand is doing, and a law is just as good as the policing of that law. I'm sitting at a number of Operation Pakistan national groups, environmental groups, and sometimes, you know, I said to my wife this morning, you know, I'm you know, it's a mess, you know, because of the fact that there's not proper policing done. For instance, also with regards to the policing of mines, they make provision for fines, and so they don't care when they get fines. The only way that we still at the Freiling case, we should move on, and we should start criminally prosecute these guys, and I think then it will stop. But until we're not that serious about it, it's my view that we're going to have trouble in the future. Thank you.
Thank you. I think it's so important to reflect on these discussions at the practical level that you've brought into the conversation. And for me, what it makes me think about is what is a justifiable economic and social development in the context of the obligation to secure ecologically sustainable development. So the fuel retailers tells us we have to balance environmental and socioeconomic considerations. The Constitution gives us some clues about how we should do that, securing ecologically sustainable development and advancing only justifiable socioeconomic development. And I think if we hear the challenges around enforcement that you've highlighted and how hopeless it can feel, we really have to question, what does this term justifiable mean? And I think, again, that's where the courts can play a role in guiding us, because they are experts in engaging in proportionality analysis, right? So yeah, thank you for highlighting some of the practical challenges.
Thank you. Are there any final comments or questions for Melanie before we close? All right, just a thank you from everyone. Okay, thank you, Melanie, as well from my side and from the team at the Global Environmental Law Centre for making the time to talk about your really important and valuable research contribution today. It was very engaging, and I think all of the academics here today were making notes on, how can we also engage on this? And of course, it definitely stimulated some thoughts just from a practical perspective. So that's great too. That's always the aim of our research, for things to filter down into practice and into government. So thank you very much. We have recorded the session and we are going to make the recording available. And perhaps, Melanie, if you are comfortable with it, you could share your slides if anyone asks for that. And then, yes, we are also going to add people to the mailing list who did register for today. We have a few webinars planned for the rest of the year, or at least until July, and then we'll resume again. The next session is going to be on mainstreaming gender into climate negotiations. That's going to be quite an interesting talk, but more information on the speaker and the time and date will be shared soon. But from our side, thank you so much, Melanie. It's been a pleasure hosting you and engaging with you, and I hope we can do so again in the future.
Thank you so much again for the invitation and for the really stimulating comments from everyone who raised questions and thoughts. I really appreciate that feedback and those comments.
Thank you. Thank you, everyone.